Welcome, everyone. We are just about to hit our starting time, and I want to just make the announcement, make sure everyone who's here is here for the discussion of the U.S. Supreme Court's impact on intellectual property rights, and we're looking at the 2016-2017 term. Lots of cases in the IP world in that term, and so hopefully we will shed some insight on those and talk about not only the cases that have been decided, but the ones that the Supreme Court has accepted for decision in the next upcoming term, including a couple that are very potentially important to the IP world, especially with regard to IPRs and the Patent Office. So, getting into it, we will have as today's presenters myself. I'm Michael Hawes. I'm a partner specializing in appeals in the Baker Botts IP practice. We'll also have Aaron Streett. Aaron is partner and chairman of our Supreme Court and constitutional law practice here at Baker Botts. Jennifer Nall will handle some of the cases as well. Jennifer's a senior associate, also specializing in appeal work here at the IP group of Baker Botts. And we're also very glad to have, again this year, Matthew Kelly. Matthew is the Chief IP Counsel, Managing Director, and Associate General Counsel for the CME Group. If you have questions during or after the program, please email Jason Rosenthal. Jason's email address is jason.rosenthal, R-O-S-E-N-T-H-A-L, @bakerbotts.com. A recording of the webinar will be circulated in the next few days, and we'll also post it at our website, which is, unsurprisingly, www.bakerbotts.com. So now let's get into the program. You'll see there's quite a bit to cover. We're going to give a brief overview of developments that have occurred in the term, but then jump right into the cases. And as you can see, we had no fewer than 8 IP cases in this term. Then we'll talk a little bit about the upcoming term and specifically talk about the 2 IP cases that have already been accepted. And then talk just a little bit in general about how this year played out in terms of overall impact of the Supreme Court on IP law. So let's talk first of all about the October 2016 term. And Aaron, if you could give us a feel for, at a high level, IP isn't everything, what was happening at the Supreme Court in this last term?
Sure. Good to join you all this morning, Michael. You see some of the key players involved in activities at the court this term. Of course, the court concluded having its longest vacancy in the history of the court, well over a year, smashing the previous record by nearly 2 months. President Trump nominated and the Senate confirmed new Justice Neil Gorsuch to replace Justice Antonin Scalia. Justice Gorsuch only joined the court in time for the last setting of oral arguments, the April setting. So he only participated in a very small fraction of the term's merits cases. What we do know is that the court continues its high level of interest in intellectual property cases. As Michael mentioned, it seems to be a secure long-term trend. A lot of people speculate that stems from the Chief Justice's background as a private practitioner and his understanding that corporations and private actors need guidance on important areas of law such as intellectual property and tax and commercial disputes. Another reason motivating that high number of cases granted in IP this term may be that the court knew that it had a possibility of being divided 4-4 and was looking for areas of law in which they typically do not divide 4-4, such as intellectual property. And true to form, the court did not divide 4-4 in any IP cases. In fact, it divided 4-4 very infrequently this term, again, perhaps thanks to the Chief's leadership in guiding the court to narrow decisions and avoiding acrimonious areas of the law. We don't know much about Justice Gorsuch on IP cases. Of course, he came from the 10th Circuit. He was based in Denver, Colorado, and did not hear that many IP cases. What we know, both based on his history and philosophy and from the early returns of this term, is that He is, as advertised, very much in the mold of Justice Scalia and Justice Thomas. He is a textualist. He elevates the plain meaning of the text far above every other consideration, and will not likely be accepting of policy-based arguments that are not linked to the text. He writes separately very frequently, even in the 1 month worth of arguments that he heard. He wrote several concurrences and dissents, and he almost always joined Justice Thomas, or Justice Thomas joined his opinions. So very much in the mold of Justice Scalia, and I think there's no reason to expect that will change. That certainly has some implications for IP law. Many times it seems to me, as a non-IP practitioner, that the dispute is between a policy argument or custom and practice and the way the Federal Circuit and other courts have always done things versus a new creative textual argument that is trotted out at the Supreme Court. It seems to me that Justice Gorsuch will be one who will elevate the text and careful intratextual and contextual analysis to reach his decisions. We also know that he is skeptical of the Chevron doctrine, whereby courts accord deference to the judgments of administrative agencies where statutes are ambiguous. He has written at length on the Court of Appeals that he believes Chevron violates the separation of powers and takes away the authority of judges to decide what the law means. So I think that will be relevant as well in the IP arena, where regulatory agencies have proffered interpretations of ambiguous statutes. Certainly can count on Justice Gorsuch to follow Chevron while it's the law of the land, but it's hard to imagine that that will not color his views and limit the amount and the scope of deference that he would give to administrative agencies. We'll see returns on that in future terms. Finally, you see to your right a picture of Justice Anthony Kennedy. Rumors are rampant. They're reaching a fever pitch that he will retire either this term or next term. That would be an earthquake for the court as a whole. The court is still divided 4-4 frequently on the most controversial cases, as we said, not so often in intellectual property cases. And the court would potentially shift to a more conservative, more textualist direction if President Trump were to appoint and the Senate were to confirm Justice Kennedy's successor in the next year or two. So that is something all SCOTUS watchers will be having their eyes peeled for this summer, but that is a good overview of the court as a whole in October term 2016.
Great, thank you. So now we're going to get into the meat of it. There are, as I said, 8 cases, so we're going to get moving because there's a lot to talk about here. And we're going to start with TC Heartland, obviously a case that has had a big impact and continues having impact with district court cases coming out every day talking about whether it was a change of the law, what impact it has on current cases, and perhaps some new areas of law that are now going to be developed because of that case. So what was TC Heartland about? It was basically about the question of where does a corporation reside for purposes of patent infringement case. And the question presented was whether, for venue purposes, does the corporation reside everywhere that its economic tentacles reach, which we've shown on the left, or only where it is actually incorporated, and we picked a random state of Delaware to show on the right. So that was the question the Supreme Court was looking at, and you have to put that, though, in the context of the statute. So the statute actually gives 2 options for venue in a patent infringement case. The first was the option that was at issue in TC Heartland. Where does the defendant reside? The second, though, is a different option. Even if the defendant does not reside in a district, if it has committed acts of infringement and has, and this is important language, a regular and established place of business, it still has venue. The decision in TC Heartland has basically given a huge increase in importance to that second prong, the question of where acts of infringement have occurred and where there are regular and established places of business. So what was the rule before? Well, the Federal Circuit had said that if you have personal jurisdiction over a corporation, the corporation resides there, which is why no one ever got to the second prong of the test, because, of course, if there was no personal jurisdiction, venue never really became an issue. However, that holding was reversed by the Supreme Court's holding. The Supreme Court said that the current version of 1391, that's that venue statute, does not contain any indication that Congress intended to alter the meaning as interpreted in Forco. So Forco was the case where the Supreme Court had earlier said that venue for purposes of defendant residence of a corporation was only where the defendant was incorporated. The Federal Circuit, almost 30 years ago, had said, well, there were changes in the statute, and that's why the personal jurisdiction test was appropriate. But the Supreme Court, looking at the current statute, has said, nope, not the case, Forco still applies. So even if there are economic tentacles across the country, at least for the first prong of the venue test, only the state of incorporation, whether it is Delaware or elsewhere, is important. So, Matthew, I wanted to get your thoughts on this. Obviously, lots of companies are very interested in TC Heartland, both in terms of its outcome and in terms of its impact. What do you think is going to be at play as TC Heartland plays out across the country?
Well, first, as a company, Chicago Mercantile Exchange is primarily a defendant rather than a plaintiff, so I will take that posture here. Knowing that it's very unlikely that I'll be in the Eastern District of Texas is a very positive move for me. For us, I see New York, Chicago, and Delaware, where we're incorporated, as the three locations that I now need to focus on in terms of where my potential patent litigation is going to be. So that limits where I need to be concerned about, and so I think that's a net positive. What I think I'm cautious on is, well, the Eastern District of Texas had some anomalies in how it ran patent cases and why so many patent cases were brought there. As the number of cases move, and I believe Delaware is going to get inundated, and I think they're getting ready for that with more cases, they may start changing their procedures, and the outcomes in those different districts might change dramatically. And we don't have any presence in California. I think that's another one that will see a significant increase. And so those courts that see their patent cases dramatically increase may either create new patent rules to deal with that, or may start ruling differently than they have in the past, either to move the cases further along, or those cases will get backlogged and not resolved for a long period of time. So I'm cautious about how happy I should be about TC Heartland, because I do think that courts that get overloaded in the future will change their past practices in some sense. And then on some ancillary issues, last time I was in the Eastern District of Texas, I was part of a joint defense agreement. We actually did a joint representation with one law firm representing multiple different unrelated defendants, and that was great cost savings. Under this new scheme, those various defendants would all have to have been sued by that patent holder in different forms, and there wouldn't have been as cohesive a joint defense group at that time. So that's something that I'm probably going to lose going forward. And then there's a concern among some people that to get the venue, either in the Eastern District or elsewhere, that some of your channel partners, your distributors, your downstream people will also be sued along with you because their activities are in forms where your activity isn't. Even if you're the company that's going to have the most money at stake, bringing in some of your customers might give them the venue to end up somewhere else. So you might have to deal with that. Fortunately for my business, that channel partnership relationship doesn't happen too much because we're not distributing physical products, nor are we manufacturing items in different locations. So I think that's something else that I would pay attention to, and maybe get your partners, your channel partners, ready for patent litigation where they might have been shielded by your deep pockets in the past.
Yep, we're going to be seeing a lot of action on TC Heartland, and I anticipate you're right, Matthew, that some of the different areas of the supply chain or the stream of commerce are going to see more attention than they've seen in the past. Turning to another patent case, we have SCA hygiene products, and this is on the issue of latches. And Aaron, would you like to tell us about this one?
Happy to. You see, the question presented is very similar to a case the court handled in the copyright context in recent years. The question is whether latches can bar a claim for patent infringement that was brought within the statute of limitations contained in the Patent Act. And if we move to the next slide, we'll see the Petrella case that the court decided, well, hard to believe, it's been 3 years ago now. In the copyright context, there seems to be a theme of the court moving from copyright to patent and applying their reasoning in the former to the latter. Copyright contained a very similar 3-year statute of limitations, and if we move to the next slide, we'll see a comparison of the statutes. You can see it's not exactly the same. One seems to refer to looking back after the claim accrued. One refers to infringement committed more than 6 years prior, but they're both statutes of limitations with a date certain after which a claim cannot be brought. You see the patent, of course, patent on the left, copyright on the right, and the court's question was whether, as in the copyright context, should a patent claim also be valid and be timely regardless of latches if it is brought within the 6-year period in Section 286. Let's move to the next slide. And we see what the Federal Circuit had done in the lower court. The Federal Circuit, as the Supreme Court ultimately decided, to not get the hint from Petrella. The Federal Circuit distinguished Petrella and decided that Congress had codified a latches defense in a way that it had not in the copyright statute. The court looked at some language from Section 282 that said the following shall be defenses. You see in your very last bullet on that slide. And one of the defenses is unenforceability. The Federal Circuit interpreted that to include latches and decided because the statute codified both latches and the statute of limitations, that latches could bar a claim even if it were brought within the statute of limitations. Let's move on to the next slide. The Supreme Court reversed in a fairly cohesive opinion. The court held together 7-1. Justice Breyer dissented. We'll see that is a theme this term. Justice Breyer is a bigger fan of the Federal Circuit than some of the other justices, sort of in keeping with his general deference to expert agencies and courts. And Justice Alito wrote the majority opinion. You see how he stated the question in the first bullet and ultimately held that latches cannot be a defense against damages where the infringement occurred within the 6-year period in Section 286. The court seemed quite skeptical that Section 282's reference to unenforceability was intended to refer to latches. As the court said, even if that did codify a latches defense of some kind, it would not bar a claim brought within the statute of limitations. And Justice Alito explained that that's largely for separation of power reasons. If Congress has prescribed a statute of limitations, that reflects a congressional judgment about when claims should be available, and it should not be displaced by judges applying the doctrine, the equitable doctrine of latches, which the court described repeatedly as a gap-filling doctrine, and explained that here there is no gap to fill. Justice Breyer saw it a different way. He said there was a gap to fill here, and that latches could be applied alongside the statute of limitations. But in any case, that effectively resolves a question that had been lingering for some time, and we'll hear now from Matthew on how that might affect corporations dealing with these claims.
So latches, you know, a lot of times it's raised, but the number of times it's actually effective in limiting the damages is pretty small in the cases I've been involved in. So, but for those, as a defendant, you're now face a larger exposure on the damages side. Most of the time, it's not going to affect whether someone's going to sue you or not. It's just going to affect how far back they can reach. An interesting thing in the financial services area, a lot of patents were filed in the late 90s, and they're now coming up towards their expiration date. So this ruling that gives them the absolute 6 years back from the date of filing does strengthen that set of patents that are near their expiration, because now their value might be more in the past than in the future. But as I said, there's been very few times where the defense of latches has actually been applied in the cases I've been involved in that actually limited the damages in a significant way. Most of the cases I dealt with, the future damages were much more significant than the past. So I think that's going to be very industry specific. And so you have to reevaluate your litigation risk from the viewpoint of 6 years past the date of filing.
Thanks, Matthew. Now we'll get to one that certainly does have a very significant impact on damages, which is impression products versus the Lexmark. Jennifer?
So in impression products versus Lexmark, the Supreme Court addressed whether a patent owner's sale of its own product exhausts patent rights when that sale is domestic inside the United States or when that sale is made foreign, and held in both cases that a sale exhausts patent rights. And so that means exhaustion is that when you sell a product, you can't retain the ability to sue for later people using that product in a different way or in a way you don't intend. There are no rights that stick to the product like a remora, which is a sea life parasite creature that can stick to the product that you sold. When you, as a patent owner, sell a product, it now exhausts all your future patent rights in that item. And so in terms of background of this case, Lexmark owns patents and sells printer cartridges, and they sell them in two ways. One is through a regular sale where the person who buys it has all rights and all title and interest in the product, and then through a return program for a discount, there's a shrink wrap license on it that says you get a discount, but you agree to return this cartridge, and so your patent rights are limited. The rights you get in this product are limited by which sale you pick, and that's what Lexmark tried to do. Impression buys used printer cartridges in the United States and refills them and sells them in the United States, and also buys used printer cartridges around the world, refills them, and sells some of them in the United States. And Lexmark sued Impression for patent infringement based on both types of sales. The Supreme Court said that contract law, the shrink wrap around the printer cartridge, is valid. You can do that, but to enforce it, you have to sue customers for violating the contract. It is not a patent law concept as the Federal Circuit had held. So what the Federal Circuit had held was that 271A, which is the statute that creates infringement, has a clause that says sales without authority are infringing sales. And what the Federal Circuit said is that without authority can be a contract issue. You can give partial authority or you can give full authority, and when you sell something, if you give partial authority and that is violated by the consumer, then it's a patent infringement because whatever is done later is without authority. And the Supreme Court said that's not right. A patent, the authority concept is not something that you can contract around. When you sell it, it is a chattel that is in the stream of commerce, and the patent owner no longer has the ability to control those sales. And with respect to issue 2, going along the same theme that Aaron mentioned earlier, the Supreme Court said foreign sales also exhaust. So if a patent owner sells a printer cartridge in another country, that exhausts United States patent rights. And the Supreme Court looked to a copyright case called Kurtzang, where it held that books sold in books sold in Asia exhausted copyright ownership rights in the United States, and it relied on the common law's refusal to restrain a person's ability to get rid of their product, the things that they own, the alienation of chattel. And that overruled a 2001 Federal Circuit case called Jazz Photo that held that foreign sales do not exhaust because no patent rights were implicated or used or exhausted by those foreign sales. I think an interesting future issue that will possibly come up is the interplay between exhaustion under impression products and a prior Supreme Court case called Quanta, where the Supreme Court discussed how does exhaustion work with respect to claims that cover more than just the single component that was sold by the patent owner. So if a patent owner sells a windshield wiper, does it exhaust a patent over a car sort of idea? And I think that impression products is going to push Quanta further, or people will try and push Quanta further to see where that goes. The other thing that's interesting is that in Quanta, the Supreme Court mentioned whether or not the component that was sold substantially embodies the claim is important. And as we'll discuss later, substantial embodiment is something that the Supreme Court addressed in a different context this term, which might also come into play here.
Now, last year we would have been done with the patent cases, but this year we're only halfway through. Luckily, the last 3 are a bit narrower in terms of what the Supreme Court actually held, though often they left some room for the courts below to move on. First, we're going to look at Samsung versus Apple, which was a design patent damages case. So for those who have design patents, this was a critical case, and for the rest of us, it meant there were really pretty pictures in the opinion. Where this came from was a question of if a design patent is only applied to a component of a product, should the award of an infringer's products be limited to the products attributable to the component or to the overall product? The product in this case was a cell phone. So Apple had sued Samsung for infringement of design patents. The jury awarded entire profits on the cell phone totaling $399 million. And you can see there the statutory language, shall be liable to the owner to the extent of his total profit. The Federal Circuit agreed on using the cell phone revenue, or the cell phone as a whole, as the profit base. Well, the Supreme Court disagreed, and they disagreed 8-0. They basically said that focusing on the end products sold to consumers was too narrow, in their words. The court held that the language was broad enough to include either the profits of the final product sold to consumers, in the case of a simple product like a dinner plate, or a component of the product in a more complicated product. And the example they gave there was oven, which was presumably less complicated than a cell phone. Rather than resolve the situation, the justices sent the case back to the Federal Circuit for further proceedings. So we know that the Federal Circuit's bright line test doesn't apply, but we're still going to need some development to know which way it goes going forward in terms of the overall product versus a component. the next case we have to look at is Life Technologies versus Promega.
So in this case, the Supreme Court addressed a statute that 271F, which is a statute that addresses whether a company or person in the United States who creates all the components of a patent and except for perhaps like the glue that sticks it together, ships it to a foreign country, glues it together and sells it, whether that's an infringement. And 271F has two portions, F1 and F2, and the first one was at issue in this case, LifeTech v. Promega. And 271F1 says if a substantial portion of the components are created in the United States and shipped abroad and then induced, where the person who ships them induces infringement abroad of a United States patent, that is infringement of the United States. And what the Supreme Court said is one component can never be a substantial portion. The facts here were that LifeTech's prior company, the defendant, had a 2006 license to the patent, and it was a very limited license. And the invention uses Taq polymerase, which is just a component that can be used in lots of things, but this invention uses Taq polymerase to do the important aspects. And later, after the license, the defendant, who is now LifeTech, shipped the Taq polymerase to the UK and combined it with other components to produce infringing kits that included all the claim elements. A jury found LifeTech willfully infringed the patents in the United States based on U.S. sales and worldwide sales, but then the district court granted Jamal and LifeTech's favor. So the Federal Circuit reversed the district court and said that a single component can possibly be a substantial portion of the components of the patented invention, and that substantial evidence supports the jury's conclusion that the Taq polymerase is a substantial portion under these facts, and I've shown a picture of what the test kit looks like. The Supreme Court reversed and held that substantial portion is not a qualitative measure, it's a quantitative measure, and that components, which is plural, can never be, a single component can never be a substantial portion of plural components. And any other read of 271F would undermine 271F2, which is that a single component that is especially made or adapted for infringement can be an infringement in the United States. And so what was not decided is, other than one component not being a substantial portion, what is a substantial portion? So here components have to be plural, two or more, and we know one is never enough. So does that mean 50% is never enough? Does it mean 51% could be? Or does it mean if you have 10 components and 3 are critically important and huge, might there be an argument that 30% is enough? And we just don't know, and so that's an issue for the future.
So now we're going to move over to copyright, and Aaron, could you tell us about Star Athletica?
Yes. Star Athletica versus Varsity Brands, another case in which the court continued its recent trend of putting pictures in their opinions, which I think is a helpful trend for understanding what's actually going on in the case. You see the question presented is the question of the appropriate test for determining when a feature of the design of a useful article is protectable under Section 101. You see some of the designs here. They're designs for cheerleader uniforms, and the allegedly protected design items are essentially the colors and what they call, what the court calls the chevrons on the uniforms, and the way they are arranged on the uniform. So let's move on to the next slide. You see the relevant statutory text there. As I mentioned before, Justice Thomas is very much a textualist in all fields, but especially when it comes to patent cases, that seems to be especially striking. You have a pretty complicated statutory test under Section 101. Justice Thomas holds in an opinion for 6 members of the court, although he really writes for 5. Justice Ginsburg concurs on other grounds. He holds that when you have a feature incorporated into the design of a useful article, it's eligible for copyright protection only if 2 factors can be satisfied. Only if the feature can be perceived as a 2- or 3-dimensional work of art separate from the useful article. You imagine the design separated from the useful article, which is here the uniform, and it would qualify as a protectable pictorial, graphic, or sculptural work, either on its own or fixed in some other tangible medium of expression. So those are the 2 factors that the court applies going forward, and let's look at how they apply them here on the next slide. So the court says the design is not a replica of the useful article. If something is a replica, it's not protectable. The court says the design here is not a replica simply because it would resemble a cheerleading uniform. If you somehow put those designs onto a piece of paper or just had them floating in the air, it would still look an awful lot like a cheerleading uniform. The court says that doesn't deprive it of protection as a replication, but the court also makes clear that the shape and the cut and the dimensions of the uniform itself are not protected. It's just the designs. This should not, in the court's view, choke off innovation in the field. The court also says that it's irrelevant that removing the designs would leave you with a plain white uniform. There's a lot of debate in the briefing whether a plain white uniform is a functional cheerleading uniform or it's not. And the court says that doesn't really matter. The question is whether the separated art is itself protectable, not whether there is some remaining useful article or not. And in that respect, the court abandoned a distinction that several lower courts had attempted to draw between physical and conceptual separability, which I won't go into here, but it was a question that had bedeviled the lower courts, and the Supreme Court said this is conceptual in nature. It's a matter of removing the designs and assessing them on their own, whether they would be protected or not, regardless of whether the remaining useful article would, in fact, be functional. And Justice Ginsburg concurred, and Justice Breyer dissented, joined by Justice Kennedy. Justice Ginsburg had a completely separate take on the question, which we won't go into here, but is an interesting read as her daughter is an intellectual property specialist. She often has interesting takeaways from these types of opinions.
Thanks, Aaron. And our last patent case from this term is one that is specific to one particular area and actually had fairly clear-cut decisions, and that's the Sandoz v. Amgen case. It concerns what are called biosimilars. I think most folks have seen all the litigation that's occurred with regard to NDAs, or new drug applications, and ANDAs, or ANDA litigation, which is an abbreviated new drug application. Well, that was a huge expansion of the patent statute, and biosimilars concern another new piece of the patent statute called the Biologics Price Competition and Innovation Act of 2009. Well, it took 8 years for our first case regarding the language of that act to hit, and there were actually 2 questions presented. First of all, can a court enforce the applicant's duty to provide the license application and related manufacturing information with an injunction? That was the first question. The second question has to do with whether the 180 days notice that you have to give can be given before the FDA gives a license. And that's, when you think about it, that doesn't sound like a huge question until you realize that there can be millions of dollars of sales a day, such that 180 days of sales can be a really big deal. So can the notice requirement be enforced by injunction? Well, the court said why it was important. They said that the act was all about allowing the opportunity to litigate the relevant patents before the biosimilar is marketed. Obviously, the patent holder would really like to do that, whereas the biosimilar marketer would probably prefer to get on the market first. So that's what this is about. But the court said no, that there is no injunction under federal law, but left open the option of one under state law. They said they agreed with the Federal Circuit in this case and said the injunction is not available because the act itself gave the relief for the situation where the applicant did not give the required notice. They did leave open the option that a particular state law might give the opportunity for an injunction, but they did give a couple of hurdles for that. One, of course, is whether the state law is satisfied, but secondly is a preemption analysis, that even if the state law were satisfied, that the BPCIA may preempt any state law remedy here. There are probably some lawyers in the biosimilar area combing through 50 state statutes trying to find ways of getting an injunction in the aftermarket of this particular case. And what was the other issue? That was the 180 days notice. And here, the Supreme Court gave a victory to the applicant, saying that the notice can be provided before the licensing. This was really just about grammar. The applicant, the part of this statute talked about giving notice of the biological product licensed under subsection K. The Federal Circuit said, well, you can't give notice of a product licensed until after licensing occurs. Whereas the Supreme Court disagreed. They said that that phrase modifies commercial marketing rather than notice, and therefore you don't have to wait till the licensing to give the 180 days notice, which effectively allows the biosimilars to be marketed much further ahead than they were under the Federal Circuit's interpretation. Again, sometimes a huge economic advantage. So that gets us through the patents, and now we turn to what was probably the biggest case press-wise, Lee v. Tam. Aaron, can you give us this one?
Absolutely. So also known as Matal v. Tam, thanks to the substitution of the official defendant in the case shortly before the decision was issued. This is the case about disparaging trademarks and whether the Lanham Act's ban on disparaging trademarks violates the free speech clause of the First Amendment of the Constitution. You see the relevant statutory provision on your screen. No trademark shall issue if it consists of matter which may disparage persons living or dead, et cetera, et cetera. And the court unanimously struck down the disparagement provision on the First Amendment grounds, but the court divided in an interesting way on the reasoning of why the statute is unconstitutional by a vote of 4-4. The lead opinion was written by Justice Alito, joined by Roberts, Thomas, and Breyer. Typically, the less speech protective justices on the court, but even they agree that the disparagement provision is pretty clearly unconstitutional. The court has to go through a fairly detailed analysis to get there, which is a very interesting read. The court first has to hold that trademarks are not government speech. When the government speaks, the First Amendment does not apply because Congress shall make no law restricting the freedom of speech does not apply to government speech. The court holds that trademarks are also not government subsidized speech. When the government subsidizes speech, it has much more flexibility to subsidize the messages that it wishes to subsidize to promote its own message. The court also said trademarks are not a sort of hybrid called government program speech. That is what the federal government urged in this case. And the example the government gave was public union dues, where members can be compelled to pay a public union dues to facilitate speech on behalf of the union. So that got the court over the question of whether the First Amendment applies with full force. The court concluded it did, and it moved on the next slide to the next phase of its analysis, which is, well, what First Amendment test applies here? And the court didn't really answer that question. They said even if it's a limited public forum, that is when a government opens up a forum for a certain type of speech, the statute's still unconstitutional because when the government opens a limited public forum, it cannot discriminate on the basis of viewpoint. And here the court is banning disparaging viewpoints and is allowing non-disparaging viewpoints. And then the court said, well, if this is commercial speech, that typically falls under a less stringent test called the Central Hudson test. Even so, the statute still fails because the regulation goes much further than the asserted governmental interest in protecting racial groups and others against disparagement. And the court gives the example that even a trademark that said "down with Nazis" would be banned because it disparages Nazis, even though that would seem to go much farther than the government's interest in protecting against discrimination. The four-justice concurrence essentially cuts through a lot of the categorical analysis that the lead opinion does and says, regardless of what type of speech trademarks are, and regardless of what test applies, the cornerstone of the First Amendment is that the government cannot engage in viewpoint discrimination, and therefore this is clearly unconstitutional. And on that one, that opinion, you have the four more speech protective justices signing on to that approach. Of course, the big question is, does this open the floodgates to a wide range of offensive and disparaging trademarks? Football fans, of course, are very interested in the Redskins trademark. I think the answer is probably yes, and I don't think the court really cares very much because the court believes that protecting speech often requires protecting offensive and hateful speech, and that's the path that we're going to go down now, and the court has essentially said the market can determine whether those trademarks meet with approval or favor or disfavor. So that certainly a big constitutional law case this term in the IP field.
Let's move on to the next term. We've got two cases coming up in the next term, but let's talk about what is going to be happening overall. Aaron, would you mind giving us some thoughts here?
Sure. The court has picked up the pace on granting cases, and it seems like we are going to have a very full term now that the court is back at full strength. We'll see Justice Gorsuch. Well, he didn't take very long to get his sea legs, but he will be fully integrated as a member of the court. We'll see how he interacts with other justices, and that will be very interesting to see as we begin to observe how he weighs in on IP cases. We'll also see whether another vacancy happens this summer, which will be battle royale on Capitol Hill and would greatly change the court if that comes to pass.
And if it does, it'll have an impact on at least the two cases that have already been accepted. And interestingly, those cases both concern the Patent Office and patents specifically. And Jennifer, can you tell us about SAS Institute?
So SAS Institute is about whether the Patent Office has to review every claim that is part of a petition for inter partes review that has been instituted in its final written decision. And so in terms of the facts, SAS filed a inter partes petition on 16 claims of a patent, and then the PTAB instituted on a subset of those claims, and then issued a final written decision on just that subset of the claims. The issue surrounds whether 314A and the interplay between 314A and 318A and these statutes. Under 314A, the director of the PTO is given authority to institute if there's a reasonable likelihood that the petitioner will prevail on at least one claim in the challenged petition. But then 318A says that the final written decision shall include any patent claim challenged by the petitioner. So the Federal Circuit said that based on a prior panel decision, and this did not go en banc, that the language in 318A is materially different than the language in 314A, and that one basis for affirmance is that the difference is that 318A is allowed, it means that it's a claim-by-claim basis. And the other basis for affirmance was under Chevron deference, if 318A is either the PTAB is right or it's ambiguous, and Chevron deference should be given to the PTAB, to the PTO. On cert, SAS argues that 318A is the plain English says it shall, a final written decision shall be issued with respect to any claim challenged, and that's not what's being done, and there's no ambiguity, so Chevron deference is inappropriate. And the Federal Circuit's decision goes against the manifest purpose of the AIA to resolve invalidity issues with respect to patents. Matal government argues that first of all, there's no jurisdiction for the Federal Circuit or the Supreme Court to review the decision whether or not to institute on these unchallenged claims. That 314D means that this issue should not even be addressed. And if the Supreme Court doesn't go with that, the AIA everywhere is talking about claim by claim whether the claims are unpatentable, and 318A also should be interpreted and is appropriately interpreted as talking on a claim-by-claim basis. Chevron deference is appropriate, and the petitioner's view that the AIA is supposed to resolve all invalidity issues is not accurate, because there are definitely invalidity issues that the AIA acknowledges will not be resolved by inter-parties review.
Matthew, I know that this one, you've been up in the Patent Office with IPRs. What are your thoughts?
Well, I think this is going to be a very important case, and it's going to have some pretty significant impacts. And I think with the more textualists on the Supreme Court, they're going to look at the actual words of the AIA, and quite frankly, not only in this case, but in other cases, I believe that the Federal Circuit and the Supreme Court have looked at the words in the AIA and sometimes taken great liberties with them. I believe here they're going to look at the words and see what the words say. I struggle with the Federal Circuit's analysis and synopsis, and then which they followed in the SAS case below, where they're trying to distinguish claims challenged in the petition versus claims challenged by petitioner. And to me, there's only one place a petitioner can challenge a claim, and that's in the petition. So those two words, while they are different, those two expressions, while they are different, and normally if Congress is going to use two expressions closely related in statutory language, and they're going to use different ones, you're going to think that there's something that's different. But I believe the Federal Circuit had to go a long way to get to their analysis that supported the Patent Office's implementation. Now, on the Patent Office's side, and this was not in the government's brief, I think their strongest argument is that the inter-parties review is the successor to the inter-parties re-exam. And so Congress, if they wanted us to do something different than we did in the re-exams, the inter-party re-exams, they would have told us. Here we got they changed the names to reviews instead of re-exams for the inter-parties. Fine, and there's some new procedures. We got 3 judges instead of the central re-exam unit. Great, Congress told us all about that. But in the old inter-parties re-exams, we instituted on some claims and ignored the rest, and we moved forward the same way we're doing it here. But I think that argument fails when you look at the actual language in the statute. Another interesting argument is the institution decisions are not appealable, which is the 314D. But we've seen that even the Supreme Court has said, yeah, even though Congress said is not appealable, there are times when it is proper to appeal it, and actions by the Patent Office and institution can be reviewed. We've seen 2 examples of that, and then they gave us a 3rd example that they called shenanigans in a hypothetical. So my takeaway is I think the Supreme Court is going to reverse the Federal Circuit and throw the PTAB into great disarray, because the rules that they rolled out in the CFR will need to be modified, because now you're going to have, under the current rules, the patent owner in their response would be able to deal with the claims not instituted or not found to be invalid in the institution decision, but the patent owner wouldn't have any form other than his original petition and perhaps oral argument. So I think they would actually have to restructure the briefing at the PTAB to implement a all claims raised in a petition go all the way through to the final written decision. So it would require some significant changes at the PTAB. Now, the ultimate impact, I think, would benefit patent owners, because those claims that right now the Patent Office does not view as invalid at the institution decision would be carried through, and the estoppel would affix to those once they got to the final written decision. Since the Patent Office is sticking at a pretty high rate to what their institution decision is with their final written decision, that would benefit the patent owners in these proceedings, and those claims that survive would be that much stronger when you went back to litigation or licensing. And so I think it's going to hearken a significant change in the PTAB's proceedings when they have to deal with all the claims that were petitioned for, and it may make the the petitioners a little bit more selective over which claims they really want to challenge, if that estoppel is going to affix to the ones that they're not successful on. So we may see some give and take. And quite frankly, a lot of the arguments, the policy arguments that are made at the Federal Circuit and by the government, to me, I think are just a whole bunch of window dressing, right? This claim-by-claim analysis. Every patent litigation is claim-by-claim. Every re-exam is claim-by-claim. Every review, whether it's inter-parties or a covered business method or post-grant, is claim-by-claim. The examination itself was claim-by-claim. So I don't think that has any merit, and that takes up a large chunk of their brief. And so I think they're actually focusing on some of the wrong issues. Supreme Court will look at the actual language and might hearken the biggest change we've seen at the PTAB since its institution.
Of course, it'll only be the biggest change if the next case goes in a particular direction, because SAS Institute is only relevant if IPRs are constitutional, and that's exactly what is at play in the Oil States case. So that one was accepted by the Supreme Court, but only as to the question of whether IPRs are constitutional. The issue, does that extinguish the value, when you extinguish a patent without an Article III forum, and Article III, of course, is the judiciary as opposed to the Patent Office, and without a jury. So those are the two issues. Is it unconstitutional for either of those reasons? Now, Oil States sued Greens for patent infringement. Greens brought an IPR, and Oil States has maintained its challenge to the constitutionality of IPRs throughout, all the way up to the Supreme Court. It didn't get a lot of attention early on. The Federal Circuit did a Rule 36, which means no opinion, but the Federal Circuit had kind of addressed the question in MCM portfolios, so that's what we're mostly seeing discussed as we move up to the Supreme Court. The main dispute is whether patents are a public right or a private right, because that's where the real issue comes as to whether you get an Article III forum or whether the government can, because it's a public right created by a regulatory system of the federal government. Therefore, Article I or agencies such as the Patent Office can do it. Now, the U.S. government says it's a quintessential public right, but that's what they said when they said the Supreme Court shouldn't take the case, and the Supreme Court did take the case. So now we have to look at some old Supreme Court law to see whether the IPRs are going to hold up. And the Supreme Court precedent that you're going to see oil states waving back and forth is going to be the McCormick Harvesting Machine Company case. There, the Supreme Court said that a granted patent is not subject to be revoked or canceled by the President or any other officer of the government because it has become the property of the patentee and as such is entitled to the same legal protection as other property. Now, the government and the respondent both say, well, McCormick Harvesting was really looking at how reissues were done at that time and was talking about the statute, wasn't talking about constitutional rights. But it's been 20 years since Markman, which was the last time the Supreme Court went back and looked at the English practice of patent law in the 17th century to decide whether something was constitutional or not constitutional. And there are a few big elephants in the room on this case. One is certainly the actual outcome of Markman. Oil States really relies on Markman, but kind of ignores the fact that what Markman really decided was, yes, you get a jury in a patent infringement case, but there are issues such as claim construction in Markman where you're not entitled to a jury. So Markman certainly does not resolve this issue. The second big elephant in the room is reexamination practice, which has been going on for many years and it hasn't been constitutionally challenged. Finally, the question is, could the Supreme Court split the baby here and say that patents that had issued before the AIA were property rights that are not subject to IPR cancellation, but those who got patents after the AIA don't have the same private property interest because they were aware in receiving the patent that it was subject to IPR cancellation. There are certainly some folks who are probably going to take that position. The actual patent in oil states is a pre-AIA patent. It was issued almost 10 years before the AIA, and it's possible the Supreme Court will only address a narrow question and leave open the question of whether those new patents, which we're going to call zombie patents, are subject to IPR. We could have a Supreme Court case that allows IPRs to go on for patents that are post-AIA, and no one will know whether those are living patents or dead patents until we get another Supreme Court case addressing the question. So on this case that's potentially wiping out a whole bunch of work by the Federal Circuit and the Supreme Court, Matthew, any thoughts?
Boy, if they reverse, this will change everything. I think it's hard for me to come to the conclusion that the Patent Office cannot take away patent rights. Not only is it the re-exams, which they started invalidating patents in 1981, we had reissues that have been going on for much longer than that, you can lose your existing patent rights. Now, that's being initiated by the patent owner, so that might somehow be treated differently. But if you're saying that the Patent Office doesn't have the ability to remove rights after a patent is granted, reissue is a problem for that. And then you could even think about someone failing to pay a maintenance fee, and the Patent Office removes your right to those claims. And then as far as the, only the judiciary can remove claims, as I understand it, the Court of Claims and Patent Appeals, the precursor to the CAFC, that was ruled by the Supreme Court back in 1929 to be an administrative body and not a part of the Article III and not even part of the judiciary. So you would have all those rulings that invalidated the patents for almost a century, as well as all the rulings at the Patent Office taking away patent claims to be found to be unconstitutional. That would be, an earthquake that the earth wouldn't survive. I think the entire patent system would not survive that kind of a ruling. And to me, it just doesn't make sense that the Patent Office, that somehow a patent is, untouchable rights, and that the Patent Office itself can't even correct its own errors. And that's, it doesn't seem to be right to me on a gut level, and I haven't seen anything from in the briefings here that would lead me to believe that the Constitution doesn't allow the agency to adjust the rights that that agency is giving.
Well, we will see what the Supreme Court thinks. It ought to be interesting. Lots of issues here that, you know, patent lawyers don't run into that often about agencies versus Article III. We may have a very interesting presentation next year with a Supreme Court decision of this magnitude. But thank you, everyone, for attending. I hope you enjoyed and were interested by all the work the Supreme Court's done in this area. We are going to, I think, try to get together again next year and see whether there has been such an IP earthquake on the cases we already know about or perhaps other cases. Thank you for coming, and I think we are done.